Well, I'm delighted to be here today with Peter Gregory, who is a very experienced court reporter and in fact has, I understand, been a full-time court reporter for at least 3 newspapers. His final period there doing that was with the Age newspaper, but he'd originally started in Brisbane many years ago and has more recently been working in Academe. And I actually consider Peter the national expert in court reporting. He's actually written the book in the area called Court Reporting in Australia, published by Cambridge University Press. Clearly, involving the media with court reporting can be contempt in the face of the court as one area, sub judice or prejudicial publicity that court reporters might embark upon, disobedience contempt if a court reporter, say, breaks a suppression order or maybe refuses to reveal their sources in court, and sometimes perhaps even the revealing of jurors' deliberations, which is another area of contempt. I'm wondering if you could talk us through, just over your years, some of your experiences with each of those, and firstly, with contempt in the face of the court.
Oh, goodness. Well, I'm just trying to remember. Look, with a bit of luck, we were relatively cautious about the way we behaved in court. I think I do remember one fellow being asked to leave a court when he was sort of smiling, presumably at whether it's something one of us had said or he'd heard some noises. And I think there might have been a workman in the ceiling who was doing some work, and you could see them reflected in the glass behind above the judge. And he was smiling and the judge was saying, look, this fellow's grinning and I'm not very happy about this. It's the opening of a murder trial and this is terrible. So basically he went outside. I think probably other people sort of gave him a little bit of a hand because he was probably a little bit unlucky as well. He'd seen something the judge couldn't see, and it was in some places extremely strict as to the way you behave. Now, these days, tipstaves, so some of the court officials, get very concerned when reporters bring their phones in and are texting or, doing other sorts of activities. And part of their reasoning is that when they go to talk to members of the public, and remembering in the Supreme Court where I worked, you often had the public sitting on a upper floor and the reporters sitting downstairs. One of the tipstaves told me, well, they'd just point at the reporters and you'd see these people texting or playing games at a slow point in proceedings. So there are lots of, I suppose, little things that you can do to make sure you don't attract the attention of court officials who are really just trying to keep the court in reasonable order.
Well, when we talk in the next segment about actual court reporting, I'm sure there'll be lots of advice you've got there on journalists' behaviour in court. I'm wondering, is there anything that you did as a matter of caution that way?
When you became familiar with the place, you would know the judges, know the court officials, know some of the lawyers. And I guess you were really concentrating on, hearing the stuff that you wanted to really hear. So even if there were some light-hearted moments or the occasional, whisper or whatever, you probably knew which judges were harder and stricter than others. And some judges would almost bring the audience or the body of the court, the people who are in court, into the situation, so some would explain things quite well.
This area of sub judice contempt, prejudicial publicity that might damage a trial.
First trial I covered was in Roma. I think it was a double murder. And I was busily taking notes during the pre-trial period, which we know is a time when you cannot be publishing a story. And the experienced country court reporter next to me said, now, you're not allowed to write this stuff, don't you? And I didn't at the time, but I certainly learned very quickly. And so in part writing the book was trying to make sure other people didn't get stuck in the same situation with no preparation. But look, we've heard stories over the years of that same sort of a thing. I think a country newspaper in Victoria was fined some years ago. And it was, if I remember the report, it was actually an accurate, well-written report. The unfortunate thing was the jury hadn't been impanelled, and I guess those of us who've covered courts over time know the golden rule during a trial, which is report what's said in front of a jury. So that was a problem. There was a case I still use from some years ago where a business writer commented during a Supreme Court trial when the accused person was giving evidence. So he gave evidence about stuff that had happened, say, on the Wednesday. On the Thursday morning, a report came out saying, oh, look, I've spoken to people who were who knew the other fellow that this witness was talking about, and no, they say he's not that sort of kind of guy at all. And the judge was furious because he saw that as an attempt to influence the trial. The reporter and the newspaper were fined for contempt of court because they were seen to be interfering with the way justice worked. And it was a pretty good lesson about the way you should conduct yourself when a trial was taking place. There have been a couple over the years where people have mentioned previous convictions, and with a few exceptions, occasionally there will be a case in which previous convictions are mentioned to the jury, but generally speaking, that's not the sort of information a jury will hear. And different media organisations have published details like that, and they've been fined because, again, it's seen to be interfering with the way justice runs.
Yeah, we've just seen that with Derryn Hinch, haven't we? Being jailed for 50 days for refusing to pay a $100,000 fine for doing exactly that. Yeah. So we'll come to that in a moment. With the sub judice reporting, you've mentioned the golden rule in court reporting is only to report what is said there in court in the presence of the jury. Mm-hmm. Now, clearly that's very important. With sub judice, there are also identification, facial identification issues, particularly with an accused in a major crime, if identification might be an issue. Yeah. And I'm wondering how, as a court reporter, you navigated that with artists and photographers and all of that kind of thing if the person's identity or their facial characteristics were not allowed to be published.
Well, I think, for example, we would often ask prosecutors and maybe check through the judge's associate, or in latter years, so here in Victoria we've had courts media officers, and you could make a check whether identification was to be an issue at trial. And by the time we were covering it in the Supreme Court, I think people had a fair idea which way they were going to go. I mean, for me, in one sense, because I was working at The Age for a long time, pictorially it wasn't as important for us as it was, say, for people covering it for television. And courts are notoriously bad for TV, for pictures. So hence the often the media scrum outside the court, the use of court artists, some vision of the place where a body might have been found or whatever. And there are different ways, I suppose, you'd try to get around that. Our principle was reasonably clear. If we knew identification was an issue, we made sure we told people back at the office that was the case. And particularly in latter times, if the court made that clear, I mean, as another example, they would also make it clear when a jury went on a view. So for people who are not used to that, after opening remarks are made in a trial, often the jurors would be taken out to the scene of an alleged crime, and they would be just shown the area. They didn't ask any questions. It was just to give them a bit of a context. And because you cannot identify jurors, the judges were very nervous about media being there. Strictly speaking, we were allowed to be unless the court made an order, and quite often the court would make an order to make it clear to us and to the people back in our offices that this was not something they wanted you to do. So I guess it really came down to communication. Victorian Supreme Court's been pretty good about that, and I guess the people who have been on their sort of court media offices know both the media and also, I guess, the legal system. So it's really a question of trying to talk to each other and work out what this trial is about.
Well, we've just had this Major Hinch case where he was both fined and ultimately jailed for all of these things coming together. Where do you see the Hinch case and these sorts of high-profile cases sitting in this area of contempt of court?
Well, I think a part of and I think you'd mentioned that part of it was a sort of a social media publication, and obviously courts and I guess everyone's going to be worried about the reach of that, because some people will have their websites based outside Australia. You also have a lot of people publishing. So it's not just Derryn Hinch who was publishing material about the case. There were a number of different places. In fact, I can remember at the time, I think it was before the case went to a plea, it was sort of around the time of the committal, Gilmar's husband and the police were basically warning people about publishing prejudicial types of information, and some places were publishing things about, the fellow's previous history. And I suppose I took a little bit of heart from that, in the sense that because I'd seen a Facebook page in which a lot of this stuff was going on, and so I then looked at it after the warnings or the pleas by the husband and the police were made. And while some people on the Facebook site were railing about their rights to free speech, other people were explaining in relatively clear terms, no, this is how the system works, and if we do stuff like this, potentially the trial could fall over, and we don't want that. And so there was actually not a bad discussion at a pretty informal and colloquial level between the people on the site. And sure enough, a lot of the material was taken down. I suppose in Hinch's case, he's very visible, and people have known of him over the years in Australia, and they know about some of the different publications he has made. The tricky bit for courts, I think, will be, okay, well, what if it's not Hinch? What if Joe Bloggs has a website and there are many other people who have websites or Facebook pages or whatever? How far do you go to punish for sub judice contempt? I mean, you might, as an outside observer, say Hinch is, I suppose, a good example because people know who he is, and they know that he understands how the law works. So he's making a fairly, I guess, deliberate, or in his case, I think he was saying, look, I didn't realise that this was up here, when it was up here, so on the website. So nevertheless, here's someone who is an experienced publisher, whereas others will argue, oh, but I didn't know that I wasn't allowed to do this. I guess if I go back in time to a time when you didn't have websites and you didn't have other people publishing, and the people called the mainstream media were the media, I'm sure I heard judges and or magistrates in Adelaide, where I worked for a while, warning people when they made a suppression order that you do not go outside the court and tell people outside the court this is what's going on. The order applies to you just as it applies to the journalist sitting over in the corner. So I guess what's happened is that person who potentially could walk out into the corridor and say something has become someone who could publish much more widely. My sense is that the more responsibility you give to social media publishers and the more information you give them to show they have to be responsible seems to, at least in the short term, have an effect. And maybe that's the way you go, because I think some of the people who are talking about their free speech rights are sensing they are being patronised. And really, I think in the books you've written and in the stuff that I've seen and written, we sort of emphasise that journalists, even if they get different privileges when they report in court, really have no more rights than an ordinary citizen. And I almost think reversing, going the other way, telling the ordinary citizen you have the same responsibility as a journalist does might help them think about what they do.
Sounds like very sound advice, Peter, in this new social media era. I think we might leave contempt there and come back to see you in our next segment on court reporting basics.
Okay. Thanks, Mark.